Good afternoon. I'm Dr. Robert Wozniak. I'm the co-chair of Education Technology at Torvalds University. Today, the topic of the module is fair dealing, which is a right conferred by the Copyright Act to the user of a work to make certain uses of the content within a specific context. After completing this module, you'll understand the basis for what constitutes fair dealing and be able to evaluate your use of copyrighted content in your educational practice. So what is fair dealing? Fair dealing is a right to reproduce copyrighted material that is conferred to the user. For certain uses in specific contexts, the user does not infringe upon the copyright protection that usually applies to a work. Similar in principle to fair use in the United States, fair dealing only applies for the purpose of research, private study, education, parody, or satire. Any other use is subject to the terms specified by the copyright owner in conformance with copyright law. Under fair dealing, the user does not need the owner's permission to reproduce the work, nor does he need to pay royalties in certain cases. However, the moral rights to the owner's work persist. Any use of the work has to be properly attributed to the author of the work and must maintain the integrity of the work unless the author or copyright owner authorizes otherwise. As an example, you cannot alter the text of a journal article without express written consent. Fair dealing is mentioned but not specifically defined in the interpretation section of the Copyright Act where other definitions appear. Fair dealing can vary from case to case. However, certain guidelines can help you decide if fair dealing can apply. First, the user must use common sense when analyzing. If the use doesn't seem fair, it's probably not. Also, there are no absolutes when judging fair dealing. It's a question of degree. The question is not if it's fair or not, but how fair is it? So, to be able to judge what factors contribute to fair dealing, the Supreme Court of Canada issued a judgment in the case CCH Canadian Limited versus the Law Society of Upper Canada, in which 6 factors are highlighted to define what constitutes fair dealing. No factor is considered more important than the other. Only a general appreciation of all the factors will determine if the use of the work falls under fair dealing. The first factor is the purpose of the dealing. To be considered fair, the dealing must fall under one of 5 categories or purposes of fair dealing that are mentioned in the Copyright Act. These are research, private study, education, parody, or satire. With regards to education, the court made it very clear that this factor must not have a restrictive interpretation. It means that education must be used in its broad definition of learning experience, and not only to an in-class teacher-to-student lesson relationship. If the use of the work is for educational purposes, it tends to fall under fair dealing. The second factor is the character of the dealing. To be considered fair, it must be used for the purpose it's supposed to be used for and be fair to the copyright owner. Even if the work is used for a fair dealing purpose, it does not mean that the user can do whatever he wants with the work. The use of the work in an educational institution without the intent to educate does not respect the character of the dealing. If there is a limited number of copies printed, if the work is destroyed after use, or if the use respects common practice in the field, it tends to fall under fair dealing. The third factor is the amount of the dealing. To be considered fair, both the amount and the importance of the dealing will be considered. The user must restrain his use to what is important in the work. For example, copying a full book but only using one chapter would not respect the amount of the dealing. The important is not the amount of the work taken, but its relevance to the use. If the amount of the dealing is trivial, or if the dealing is closely tied to the activity, it tends to fall under fair dealing. The fourth factor relates to alternatives to the dealing. To be considered fair, it must be demonstrated that no other equivalent option is available. If there is another option available to the user that does not infringe copyright, it must be taken instead. For example, if there is a glossary in a copyrighted book and another one available for free online, the online version should ideally be used. It is important to note that if the copyrighted material would enhance the quality of the education compared to the non-copyrighted material, it should not be considered an equivalent. The onus is on the user to demonstrate that using the copyrighted material is better than using the material that is not copyrighted. In our example, if the free online version of the glossary is less exhaustive than the one from the copyrighted book, it would be fair to use the glossary from the book instead. If there is no alternative work without a copyright, or an alternative exists but is not equivalent to the copyrighted work, use of the copyrighted work tends to be considered fair dealing. The fifth factor is the nature of the work. To be considered fair, it must serve the greater good and be beneficial to the public. Usually, an educational purpose tends to be identified as for the greater good of the public, since education is considered to be a right and a means of advancing society. But if the copyrighted material is used only in a confidential manner and does not allow for public scrutiny, the nature of the dealing is less likely to be considered fair. Using a copyrighted work to do a study whose results will be kept confidential wouldn't be very appropriate, as it is not for the greater good. If the copyrighted material is used in a socially acceptable context and the result is widely published, it tends to fall under fair dealing. The sixth factor is the effect of the dealing on the work. To be considered fair, the copied work must not have a negative effect on the original work in the marketplace. If the copied work makes the sale of the original work dwindle, it can have an impact on the decision since it harms the copyright owner. An education institution that provides copies of a work with a lower price or packaged in a way that directly competes with the original work might be construed as unfair competition to the copyright owner. That said, impact on sales alone is not considered as the determining factor in evaluating the fairness of the dealing. If the copy of the original work does not compete directly with the original work, or if there is no measurable effect, it tends to fall under fair dealing. In 2012, there was a major update of the Copyright Act, known as the Copyright Modernization Act. For educational institutions, it is of great importance. First, education is now an area covered by fair dealing. Before, only research and private study were considered fair practices. Second, the modernization also integrates new technologies and educational practices which were not previously covered. Third, it specifies what can constitute fair dealing in education, namely, having a significant benefit and enriching the educational environment. It also defines what constitutes an educational institution that can use fair dealing. First, the institution must be dedicated to education. It means that its central mission must be education. Second, it must be licensed, controlled, or under the jurisdiction of a body of government or its subsidiary. Third, it must be a non-profit organization. So, what practices involving new technologies can be considered fair dealing? First, it is considered fair to publicly display a work on the premises of the educational institution via telecommunication. However, fair dealing does not apply if the work or subject matter is commercially available in a medium that is appropriate to the purpose. For example, if a work is only available in paper form and the teacher needs an electronic version, it would be fair to scan the written text. To be considered commercially available, the work must be available on the Canadian market within a reasonable time and for a reasonable price, and be found with a reasonable amount of effort. Second, it is considered fair to display a live performance at the time of its communication, like a TV show at the time of its broadcast. However, it does not apply if the communication was received unlawfully. Third, It is considered fair to display a news or commentary program via telecommunication. It is also considered fair to make one copy of this program, except for documentaries, for the purpose of performing the copy for students. However, fair dealing cannot apply if the communication was received unlawfully. Fourth, it is considered fair to copy a work available through telecommunication. Only one copy of the work can be made, and it can be kept for up to 30 days after copying. If the copy is not destroyed after 30 days, the user must pay royalties and comply with the terms and conditions set by the owner. The educational institution must keep a record of the process by noting the date of the copy, its destruction, its performance in public for which royalties are payable, and it shall also mark the copy in the manner prescribed by regulation. However, fair dealing cannot apply if the work was obtained unlawfully. It is considered fair to communicate a lesson by telecommunication that contains copyrighted material. It is also fair to make a fixation of the lesson, otherwise known as a permanent copy of the live material, for this purpose. However, the audience must consist only of students registered for the course. The educational institution in this case has obligations. First, it must destroy permanent copies of the lessons within 30 days of the date that the students received the final course evaluation. Second, it must take measures to limit the telecommunication to the intended audience. Third, it must take reasonable measures to prevent the students from making a permanent copy, reproducing, or communicating the lessons other than for their express personal use. On the other hand, students also have certain obligations. First, a student may copy the lesson in order to be able to listen to or view it at a more convenient time, but only for personal use. Second, the student must destroy any copies of the work in his or her possession within 30 days of receiving the final course mark. It is also considered fair to make a digital copy of a work with the same general conditions as outlined within the framework of an existing reprographic reproduction license, and to share it with the students that are enrolled in the course. Students may print one copy for their personal use without infringing the copyright. The educational institution is responsible for limiting the number of copies printed to one per student. The institution must also take measures to prevent the digital reproduction from being communicated to people that are not enrolled in the course. It is also considered fair to reproduce, communicate, or perform content available through the Internet under certain conditions. First, the user must cite the source, in this case the URL, where he found the work. Second, he must cite the author, the performer, the maker, and/or the broadcaster. You should be aware that there are also some exclusions. First, use of any content protected by technological measures that restrict access, also known as a digital lock, is not considered fair dealing. If the content requires the creation of an account with a login and password, this qualifies as a digital lock. Second, if a clearly visible notice on the website prohibits copying the work, it is not considered fair dealing to copy the work. If no such notice is present, it is considered fair. Third, if the user knows or should have known that the work was made available without the owner's authorization, its use is not considered fair dealing. This usually applies to content that was acquired illegally, such as a movie posted on a streaming server by a third party that is clearly not the owner of the copyright. It is also important to mention that the use of fair dealing by educational institutions is subject to limited liability. The owner of the copyright may not receive more than the royalties that would have been paid under the reprographic reproduction license in use, such as copyback. If the work does not fall under the license, the royalties paid are equivalent to what would be paid if the work was part of the reprographic reproduction license. For example, if a work is not part of a reprographic reproduction license, but a similar work is licensed at 15 cents per page, then the teacher could use this exempted work at the same rate of 15 cents per page. There is no compensation to be paid if only one copy of the digital work is made by the student. It is important to note that these copies must not have been made with a motive of gain, in accordance with the fundamental principles of fair dealing. This means that the educational institution cannot charge or recover fees that exceed the reproduction cost plus overhead. So you're now able to define what constitutes fair dealing and to evaluate whether your use of copyrighted content for the purpose of education is fair. For more details on fair dealing and its application to educational institutions, you can consult your librarian or the intellectual property specialist of your college. You can also consult the Useful Links page for more information on a specific topic. Thank you for attending my session today.